IVM.
Hi guys, and welcome to Know Your Kanoon. This is Amber from Amrana Ventures, and in today's episode we are covering and continuing our journey on the Indian Constitution as a continuance to our Independence Week, where we talk about what the Constitution enshrines. We as Indians, I would like to start with, are constantly in a mix of what is our freedom and what is our rights. We are not pretty sure between the distinctions, so I'm going to start with, let's say, the rights first. And first and foremost in the line, and the most important one, is Article 14 of the Indian Constitution, which talks about fundamental rights, and it talks about the right to equality. Now, in a layman's term, right to equality means that I should be equal to you in terms of everything, starting from the minutest of the details to the major. But those are private, I would say, differences between two set of individuals. As far as right to equality is concerned, that is to prevent discrimination by state in all entirety to individuals on such a level and extent that they should not be discriminated by the state, and that is the government, in any phase of their life. So right to equality means equality before law. It means that you should be treated as equals amongst equals, and there would be no distinction on the same. The right to equal law also states that no person will be discriminated or will be denied equal representation before law due to discrimination on grounds of religion, race, caste, sex, or place of birth. Right. So this is what it is. Now let's start with the purpose of the law, of this particular section, and how it operates, applies to the Indian society. So I'm going to go para wise para and talk to you about it. Of course, I'm not reading the text from the Constitution, but I'll give you a summary of what it is and how it should be. Right. So right to equality given under Article 14 of the Indian law is one of the most fundamental rights. It ensures the guarantee to every person that the right to equality before law and equal protection of the laws. It is not only the right of Indian citizens, but also the right of non-citizens. Article 14 certainly states that the state shall, and the state shall of India, which means that no one should be above the law and all are equal in the eyes of law. Well, when we say the term the state shall of India, right? So Article 14 is trying to say that nobody in the eye of law is above the law. Everyone is below the law. There is going to be the concept of rule of law, and one cannot overrule that, right? The state cannot deny to any person equality before the law or the equal protection of the laws within the territory of India. The prohibition of discrimination on grounds of religion, race, caste, sex, place of birth, none of these factors can take into picture to discriminate with any individual, whether a foreigner or otherwise who's residing in India on a temporary visa or visiting the state. He shall be enshrined all of these rights that are there. Right. A very important text states that, let's say UK, which follows common law, and Canada, which follows common law, so far so on New Zealand and Australia as well. What equality means there is that, in all of the operations in them, that every official, starting from the Prime Minister down to a constable, a collector of taxes, is under the same responsibility for every act done without any legal justification as any other citizen. Thus, in case all of these authorities that are operating within this gambit of the Indian Constitution do so or act outside the authority or the legal authority given to them, then they shall be held accountable for their actions. Right, the phrase equality to the law, as we talk, finds a place in all written constitutions that guarantees fundamental rights. All citizens, irrespective of birth, religion, sex, or race, definitely are equal before law. There shall not be any arbitrary discrimination between one citizen or class of citizens and another. By arbitrary discrimination, I mean a one-sided discrimination which is done on purpose owing to some things that you cannot change, such as religion, caste, creed, sex, which what you're born with. Of course, religion being subjective, you can always change your religion, but what I'm trying to imply from a legal point of view is these are some characteristics you're born with, right? All citizens therefore shall, as human persons, be held equal before law. And all inhabitants of the Republic of India are assured this equality. Also, another important point I would like to bring out is, uh, you know, that is that equality before law also means the equality amongst equals. The law should be equal for all, and equality amongst equals means that I cannot compare you to someone who's not equal to you or who's unequal to you in a given situation. Your circumstances, your situation should be one that is compared to others equally in parity, those who are going through same circumstances, and it should be equally administered. People should be treated alike, right? So there won't be any difference. The right to sue, to be sued, to prosecute and prosecuted for the same kind of action should be the same for all citizens of full age and understanding, without distinction of race, religion, wealth, social status, or political influence. That's pretty simple to explain. In order for me to claim the right of equality, there is one thing that has to be seen, and that is that in case of infringement happens from a government side, I should not be given a preferential treatment if I am wealthy, if I have a different social status, if I have a political influence, if I am of a particular religion. This enshrines us equality before law in all circumstances. The doctrine of treatment of equals amongst equals is different in Canada. Principle remains the same, but application is much different. There are different grounds, but that's a uniform society. India is a diverse country with so many religions, so many subdivisions of caste, creeds, and our culture as it stands. So thus we need to create equality on those levels. Now I'll come to the next section to this, which is that, since equal protection of law has been given in Article 14 of our Constitution, right, this has been taken from the Section 1 of the 14th Amendment Act of the Constitution of the United States, right? So US also talks about equal protection before law. Our Constitution, as we know, is a summary of so many constitutions from around the world, where we took out the best parts and compiled together and made the best constitution and the lengthiest ones. So I like to start with the case law, just to summarize what we spoke about. There's a case law called Stephens College versus University of Delhi. The court, the apex court under this, held a very strong expression, which you must, for aspiring law students and otherwise, you must cohere it to, and it is most applicable to us. It is that equal protection of the laws is now being read as a positive obligation on the state to ensure equal protection of laws by bringing in necessary social and economic changes so that everyone may enjoy equal protection of laws and nobody is denied such protection. If the state leaves the existing inequalities untouched by these laws or its laws, it fails in its duty of providing equal protection of its laws to all persons. State will provide equal protection to all the people of India who are citizens of India and as well as non-citizens of India. For students out there, why I quoted this, of course, I'm talking in principle about this. It is one of the landmark case laws. You must quote it in your answers. Pretty easy to understand, right? There are also certain exceptions to rule of law. Now, let me first talk about what rule of law means. Rule of law is nothing what I'm talking about. It is just what we covered earlier, that everybody stands equal before law. However, there are certain positions, certain situations where, there are different mechanisms to hold people accountable. There's a different mechanism to hold public accountable. There's a different mechanism to hold the government accountable. Though it's a matter of dispute in India how we hold officials accountable in India. Elsewhere abroad, you can bring direct personal suits against most of the individuals in common law jurisdictions. You don't have to stick to a government or a court. But there are certain positions globally around the world that cannot be prosecuted by public in general, right? So let's see what these exceptions are with regards to the concept of rule of law. So starting first, the most exemplified example is that of the Indra Savani case, which we have, let's say, to our Indian Constitution or to the founding principle of the Indian Constitution on the concept of rule of law, right? So Indra Savani laid down that, Article 14, which talks about equality, is not only limited to citizens or persons, but it also covers something which is corporation, which is not a living person, but is given the same treatment and status as that of a living person, right? So a corporation, which is a juristic person, is also entailed to the benefits of this article. This concept basically in Indra Savani implied that equality for equals aims at striking down hostile discrimination or oppression of inequality. Similarly, Mr. R.P. Prasad case, if I'm not sure if you know, versus State of Bihar, AIR 1978, Supreme Court, reference 327. It also spoke about the same concepts as Indra Sohani, right? And it highlighted that the aim of the concept equality before law and equal protection before law is equal justice. Thus, from an answer perspective, in Indra Sohani and in Ramesh Prasad, there is an expansion of what I would call the interpretation of the law, right? So, equality before law extends to non-living persons as well, and corporation is given as the same status as that of a living person. And also, it means equality to justice. All right. So, what is the underlying principle when we talk about these two case laws? The principle of equality is not the uniformity of treatment to all in all aspects. It only means that all persons similarly circumstanced shall be treated alike both in privileges conferred and liabilities imposed by laws. Equal law should be applied to all in same situation, and there should be no discrimination between one person and the another. Pretty simple, as I said again, two set of people under same circumstances, same status, same let's say, same background, having same set of problems, they shall have representation equal before law. This does not talk about the uniformity of treatment to all in all aspects. It only means that all persons who are similarly circumstanced shall be treated alike. I cannot compare apple to oranges or oranges to apple, but when I compare oranges, there should be an equal treatment. When I compare apples, there should be an equal treatment, right? So that remains there, that I should be in a similar situation. For example, if I claim breach that I am not entitled to a pension or to a section, whereas someone else is is getting the same, then that person must be equivalent to me. It cannot be someone who's non-comparable, right? So just to give you an example, if let's say I compare myself to to women, and I say that certain women are entitled to that, but I am not, then that would be a different scenario, because it would not be a term of equals in that operation of law. In generality, yes, but for that specific statute which provides for a certain provision for women, I cannot claim the same. Though there might be different provisions. That's one example. Example number two would be in case where the granting of, let's say, by a statute of a certain compensation is there, and the compensation is not based on sex, class, creed, etc., but it is being granted to one situation, which is, let's say, a reserved set of individuals, and they are only entitled to it, and I start questioning that, then in that case, I have to see what is comparable. I have to see a factor that renders me equivalent to that claim that I'm leaving down. So it has to be treatment amongst equals, where I stand equally before the law. Right? I spoke about rule of law generally. Now, let's talk about rule of law a little in detail. The rule of law is embodied in Article 14. It is the basic feature of the Indian Constitution. It cannot be destroyed even by an amendment to the Constitution under Article 368, which talks about the amendments. Right? So it is so rightly enshrined that we cannot change it. What is the meaning of rule of law? Again, I'll simplify it. The rule of law has been given the expression, the guarantee of equality before law. It means that no man is above the law. All are equal in the eyes of law. The origin of this concept around the world, and for lawyers who are budding, you would know it comes from Magna Carta, which talks that law is equal for all in the same line, because state has no religion and all are equal in the same line. And uniformity will be applied for all. Every organ of the state under the Constitution of India is regulated and controlled by the rule of law. Right? Absence of an arbitrary power has been held to be the first essential rule of law. The rule of law requires that the discretion conferred upon the executive authorities must be contained within clearly defined limits. The rule of law also permeates the entire fabrics of the Constitution of India, and it forms one of its basic features. The rule of law shall also be delegated to all authorities representing the government of India, which is municipal bodies, local bodies, state governments, and any other branches of the government in all entirety. So you have to see rule of law from that perspective. Now I'll talk about the Article 361 of the Indian Constitution. This is an exception to rule of law. The exception is pretty simple. It says that the president, the governor of a state, shall not be answerable to any court for the exercise and performance of the powers and duties of his office, or any act done or purporting to be done by him in exercise and performance of those powers and duties, provided that the conduct of the president may be brought under review. Now, this is an important point. We spoke about it earlier, that why this is done, or that or this position is held, because he's holding an official duty which is important to the nation, but there is accountability in a different way instead of a direct accountability in terms of public putting lawsuits left, right, and center, right? But let me explain it to you why it is like that. So let's look at Article 361 and read through what the provisions are. So Clause 1 states that the President or the Governor shall not be answerable to any court for the exercise and performance of the powers and duties of his office, or any act done purporting to be done by him in the exercise and performance of those powers and duties, provided, this is the proviso, which is an exception, it states, provided the conduct of the President may be brought under review by any court, tribunal, or body appointed or designated by either House of Parliament for the investigation of a charge under Article 61. Provided further that nothing in this clause shall be construed as restricting the right of any person to bring appropriate proceedings against the Government of India or the government of a state. Pretty simple. Bodies appointed to prosecute any of these gentlemen holding these titular positions representing the Indian public can only be questioned through these means which have been provided. As I spoke about, no direct suits can be put in, but whatever suits we're talking about here can be through these channels which are provided. Coming to clause number 2, no criminal proceedings whatsoever shall be instituted or continued against the President or the Governor of a state in any court during his term or office, and no process for the arrest or imprisonment of the President or the Governor of state shall issue from any court during his term of office. Right. Lastly, no civil proceedings in which relief is claimed against the President or Governor of state shall be instituted during his term or of office in any court in respect of any act done or purporting to be done by him in his personal capacity, whether before or after he entered upon his office as a President or as a Governor of such state, until the expiration of 2 months next after notice in writing has been delivered to the President or Governor, as the case may be, or left at his office, stating the nature of the proceedings, the cause or action thereof, the name, description, and place of residence of the party by whom such proceedings are to be instituted, and the relief which he claims. So all of these clauses are excluding the titular heads from prosecution, but bringing them liable in phased manner according to the norms laid down by the Constitution, right? This has been a matter of conflict in India all along, where people have said that the leaders are not accountable, the right bodies do not question or prosecute them, where the common man and the accountability is an issue. It's a totally debatable concept, but right now here we're talking only about the Constitution and what it grants. Important case law to this effect is of Srinivas Theatre versus State of Tamil Nadu. The judges there held pretty simply that that equality before law is a dynamic concept having many facets. One of them is that there shall be no privileged person of class and name that shall be above the law, which is the state law. A fact there is the obligation upon the state to bring about through the machinery of law a more equal society envisaged by the preamble of the Part 4, which is the directive principle of state policy of the Indian Constitution. Thus, this is highlighting and talking that we must have ombudsmen which really can question the authorities. Of course, we've had draft laws and other laws like the Lokpal which came in for questioning these authorities, but those are not strong enough right now, I would say, or do not have a mode of operation given to them. Right now, I'm going to talk about special provisions which have been created, and these are exceptions. So laws can be created by state for upliftment of certain sections of the society to make them equal amongst equals, right? So these are called, the prohibitions, I would say rather. Let's look at these exceptions or prohibitions or permeations or whatever you would want to call them, right? So Article 14 permits classification but prohibits class legislation. The equal protection of law guaranteed by Article 14 does not mean that all laws must be general in character. It does not mean the same law should apply to all persons. It does not mean that every law must have universal application for all persons, right? All persons or all people are not by nature, same, and they're in the same position. The varying need of different class of persons among requires separate treatment. From the very nature of society, there should be different places, and legislature controls the policy and enact laws in the best interest of the safety and security of the state. So, what I'm trying to say here again is that the government has full right to enact laws on the basis of these discriminations which we've spoken about, to ensure that individuals are given equal treatments and the underprivileged are brought equal to the privileged. Though I sincerely would like to state that India is such a developing and a diverse cultured state, and when we compare ourselves to other constitutions and globally around the world, saying that we are a body which is very not on the same terms of what the British have, what the Europeans have. Please understand that the uh, the segregation on religion, caste, creed, etc., is not so permeated that as we have here, because it's so permeated here that in order for a law to operate, it would create discrepancies, because we, from a political perspective, from a regional perspective, are so regionalized that as a nation, it's difficult to have one law that would treat equals and leave some people underprivileged. So I would still suggest that, such laws are required in India to to bring equality. Whereas around the world, where equal laws are there, it's about equal rights guaranteed under laws in terms of compensations and so forth, so on. Here in India, the fight is different. It starts on human rights first, and then extends to caste, then creed, then color, then religion, then sex. So we have a long way to go, and such an article definitely suffices that. Right. So let me talk about special provision for women and children, and for other reserved classes such as SC, ST, and backward classes, as mentioned by the Constitution with regards to Article 14. Right. So Article 14 of the Indian Constitution says that all are equal in eye of law. Right. No one can prevent the state from making any special provisions for women and children. For example, special seating arrangement for women in buses, trains, metro trains is not unconstitutional. Reservation of some seats for women in colleges is also held to be constitutional. Similarly, according to, if you see IPC, the Indian Penal Code, there's a section of 497 which says adultery is considered as an offence when it is committed by men and not considered an offence if committed by women. Thus, women cannot be prosecuted for being in a better or for abetment. Right, and I've spoken a lot about this issue. So it is clear that it makes special provision for women, which is valid under Constitution law, Article 15(3). Section 437 of CRPC also, restricts the release of an accused person convicted of a capital offence on bail, except if the person is a woman or a children or child under the age of 16, or someone who is ill or infirm. Right, so pretty simple explanations. I'll name the case law also, the Choki versus State of Rajasthan, which says that it is valid on the grounds to make special provision for women, and therefore it is protected under Article 15(4). Right, so this actually, the amendment which was brought in has changed in the Supreme Court case of Madras versus Champakam, right, which was a case which was based on caste and religion, and it changed this reservation which was brought through, and stated that reservation of seats for the admission to State Medical Engineering College was made on grounds of caste and religion. The court said it is unconstitutional on the ground, and that it was based on a communal matter, and such matters which are not secular in nature have to be unconstitutional. Right, the aim of this particular section of 15(4), right, it has been upheld in most of the areas in Choki versus State of Rajasthan, but also dissuaded in Madras versus Champakam, is because the aim is to empower the government to make special provisions for betterment of educationally and socially backward classes of citizens, and for the SC and ST tribes. And thus, if that purpose is not fulfilled, the law looking at some other purpose, it will have to be struck down, and it cannot be upheld. Right. So amongst equality, pretty important set of cases. I'll conclude with Air India versus Nargesh Mirza, which was there. It was one important with regards to airlines, where Regulation 46 of the Indian Airlines Regulations provides an air hostess will retire from the service upon attaining the age of 35 years, right, on marriage, within 4 years of service, or on first pregnancy, whichever is found earlier. But Regulation 47 of the Act stated that the managing director had the discretion, right, to extend the age of retirement by 1 year at a time beyond the age of retirement up to the age of 45 years, at his option and disposition, if an air hostess was found medically fit. Thus, it was held by the court clearly that an air hostess on the ground of pregnancy was, was unreasonable and arbitrary, right? Because you cannot fire somebody just only on the grounds of pregnancy, and say that now you're married, you're pregnant, you cannot serve and continue your term. Right? Of course, the regulation did not restrict the marriage after 4 years, and if an air hostess, after having fulfilled the condition, became pregnant, there was no ground why the first pregnancy should stand in way of her running the service. And the court specifically said that the termination of service on pregnancy was manifested unreasonably and arbitrary on the basis that it was violation of Article 14. So pretty simple. Air India got screwed pretty badly. Nargesh Mirza said that all have equal rights. You cannot impose such conditions on women where they have capacity to be natural and equal to men. And such conditions are arbitrary in nature, restricting them against their biological nature, their self-nature, and as humans completely, defeating the purpose for what it was. Right. Another important constitution, let me tell you, is of DS Nakara versus Union of India, a case we've read a lot of time. It stated that Rule 34 of the Central Services Pension Rules was unconstitutional on the ground that the classification made by it between pensioners retiring before a certain date and retiring after the date was not dependent upon any rational principle. It was arbitrary and the infringement of the article of the Constitution of Law. Those of law students who want to go in, please have a look at this case law. It's pretty important. It's actually very similar to very other common law cases which talk about retirement. I've had parallel jurisdictions in Canada and Australia where they've said compulsory retirement of individual at the age of 65, and a lawsuit was brought against this piece of legislation by the citizens saying that how can you retire somebody just because they're 65, and there were different grounds that were pressed upon. So this is on lines with that. Please do go through the case law. It will really help in explaining what I'm trying to put through the legislation here, right? So on this ground, one last case law maybe we can talk about is John Valla Motam versus Union of India, Indian Succession Act of 1925. Section 1118 was there. It was invalidated because it prohibited the right of a Christian to make valid will for a religious or a charitable purpose only if he made it at least 12 months before his death. The court pretty clearly said that the prescription of time and the application of the provision only to Christian are artificial, having no nexus with the object of law. Right? So, again, secularism is not there. It is only sticking to law. The object and purpose, the pith and substance of the law has to be seen. Right? So, one must have to establish that, and where one feels that, the purpose and object of the law is violating his or her personal rights, or is in a way supporting one sect of individuals, not the other, whether secularly or otherwise, you have the right to approach the court under Article 14 through the Supreme Court or your other machinery which is available to you. Right? Thus, I would like to conclude with this, that this was just a short running summary of Article 14. If you guys have more questions, I'd like to put that in. Case laws that I've stated are ones that I had used in my examination times, and certain, it's huge. If I talk about Article 14, it's huge, but it would be just fair enough to give you a summary of what this section means, right? So keep listening to us, and thank you so much. We'll be coming up with next all the other sections that are there. Thank you for listening to Know Your Kanoon. Catch Know Your Kanoon on the IVM website or the app or anywhere you get your podcast from.
I hope you enjoyed that show. So it's been a really fun week on the network. Please do definitely check out all the regular shows that you do. But in addition, let me give you a few recommendations. On Agla Station Adulthood, Ritasha and Ayushi talk siblings. Really fun episode. I think you'll enjoy that. Nishad Pai Vaidya is on Cyrus, and they discuss cricket and a lot of different things around cricket. I think you'll enjoy that as well. Old friend Parmesh Shahani, he was on Absolutely Right. Definitely do check that out. Tamal Mills was on Edges and Sledges, another episode which I've heard really good things about. I haven't heard it yet. I need to listen to that soon. And guys, Uncle Please Sit, definitely listen to that. They've been killing it. This week they have Abby Phillips, he's a doctor talking about medical misinformation. Last week Paramita Vora was talking about sex education and who needs it. They've been really killing it. Definitely do check that out. And with that, hope to see you again next week.
Entertainment is like food for the brain. It's a window to culture and a great way to understand the world around us. The internet has changed what it means to be an entertainer, creating new storytellers with millions of fans. It has spawned a new breed, the story sellers, those behind the scenes creating the business for this ecosystem. They work with brands, platforms and channels who are keen to capitalize on an audience hungrier than ever for more stories. I'm Vineet Kanabar, and I have a ringside view to how stories are told and sold. On my show, I bring you creators, artists, executives and marketers for a freewheeling conversation around the business of entertainment. Tune in to Storytellers and Story Sellers for personal stories, analysis and criticism every Thursdays as I talk to the brightest minds telling or selling great stories today.